Good afternoon, ladies and gentlemen. As for the class schedule, we'll have to get a limited delivery of future interest, mainly looking into some of doctrines. Concerning the executed interest, there was a doctrine of uses. In feudal times, it was frequently found expedient to vest ownership of property in one person who would hold for the use and benefit of another. One early example was where O, going off to fight a crusade, enfeoffed his brother A, with the understanding that O's wife and children would have the use of the land. The common law courts refused to enforce uses, but the chancellor compelled the feoffee to uses A, to hold the land in accordance with the understanding on the ground that it was unconscionable to permit A to violate the confidence reposed in him. By the time of Tudors, the great part of English land was held in use. So one other illustration is to be made, what I call the Statute of Uses, enacted in 1536. So it was developed in the context of Tudors. The event of a popular use in land happened because by raising a use, a feudal instance could be avoided, and the rich then now wanted to avoid taxes. Feudal instance fell due when the cession of the land descended to heirs upon the death of tenant. To avoid death duties, clever lawyers invented a device whereby cession would almost not pass at the death of person, or would enfeoff A, B, C, D, and E, and the heirs as joint tenants to use of B for life, then to the use of all four sons in fetail, then to the use of all second son in fetail, and so forth. Under the theory of joint tenancy, no cession passed to the surviving joint tenants when one died. When the number of joint tenants hold cession grew dangerously low, some more persons could be enfeoffed jointly with them. It was principally the use of the use which deprived the crown of its feudal revenues that brought on the statute of uses. To restore his feudal revenues, Henry VIII forced the reluctant Parliament to enact the statute of uses in 1535 to become effective in 1536. The purpose of the statute was to abolish uses, turning them into legal estates, which would be subject to all the usual feudal instance upon death of the legal owner. The statute provided in substance that if any person be seized of land to the use of another, the person having the use shall henceforth be deemed in lawful season and possession of the same land in such like estate as he had in use. The statute is said, therefore, to have executed or converted the use into a legal estate. But the statute of uses has been accepted as a common law statute in most states. However, you need to note some states have not accepted it and others have repealed it. All of this matters little, however, because in all jurisdictions, the two basic reforms of the statute are effective. A conveyance can be made by deed, and springing and shifting interest can be created. And next, we need to brief on the rule about a destructibility of a contingent remainders. The common law upholds an abeyance or gap in season. A feudal instance fell due upon the death of the person seized, and the location and a continuity of season was important to the collection of feudal dues. Therefore, the courts laid down this rule. If, upon termination of the preceding freehold, the holder of the remainder is not able to take season because his remainder is still contingent, the remainder is destroyed. The recognition of executory interests has no effect on the rule of destructibility of contingent remainders. Contingent remainders continue to be destroyed if they did not vest at or before the termination of the preceding a freehold. Along with this rule, you need to be aware of the rule against perpetuities. The rule against perpetuities states that no interest is good unless it must vest, if at all, not later than 21 years after some life in being at the creation of the interest. The fact that executory interests were indestructible made it necessary, also the judges thought, to invent the rule against perpetuities to curb them. Otherwise, by a succession of a shifting interest, land could be tied up in family indefinitely. For example, O conveys Blackacre to A and his heirs. But if A dies leaving a son to such a son and his heirs, and if such son should thereafter die, leaving a son to such a son and his heirs, and if blah, blah, blah. So it is indefinite in there. Once the rule against a perpetuities was developed, it was extended to contingent remainders. At that point, the movement to abolish the destructibility rule caught fire in England and in the American states. Today, most states have abolished the destructibility rule, and only the rule against perpetuities governs the duration of a contingent future interest. Okay, let us call it a freehold interest, and we now begin to discuss a non-freehold interest. Before that, I'd like to show some more pictures. So that to be comfortable against this hard lecture. Okay, you see, the first picture, I like to let you be available with some pictures surrounding the liberation of Korea from the Japanese Emperor. As with our civilization from the civil tradition, we can be a little released from the hard rules we try to learn. The first picture portrayed some of desperate farmers in 1940s and indicates the context of land reform that provoked the directive of newborn South Korea, which is even a politically oriented. The second and third picture it is surprising to see the Sangdo was patronized by Jordan people. It actually was one of the favorites of a Jordan people. So we have developed our cultural contents to explore. Contributes to produce much of a Korean income for Koreans. The second picture shows the internet page of ads about the TV drama Sangdo. Can you identify the Chinese character placed on the right of the page? Which means the ethics of merchants. That is one of my favorite either, and I like to introduce, try to be moderated with the scene about the sensitive agenda of gender reform, which was persistently raised through the political elections. So, what is non-freehold interest? Inter alia, what we call land law, tenant law. Landlord tenant law is a blend of property law and contract law. A lease is both a conveyance of an estate in land and a contract containing a promises between landlord and tenant. In order to have a landlord-tenant relationship, the landlord must transfer the tenant the right to possession of the premises. Except for freehold interests, freehold estates, a leasehold is the only other interest that gives the holder the right to possession. Other interests, such as an easement, license, or profit, entitle the holder to use another's land, but do not give a possession. As you see a definition, you can have some comparative idea relating with the civil law real property. The most close concept can be illustrated with the right to exclusive use set forth in Articles of Korean Civil Code. You can see visually the structure of real property law in Korea. We are on this page. For summary of the right of real property in Korea, we have two classes for the purpose of generalization. The first class would be the right to exclusive use, while the other are the mortgage rights. The way of conceptualization differs between two systems when you look into the substantive nature of both traditions. To say, Korea derives a key element between use versus mortgage, while the U.S. law prefers the movables versus immovables or land. As there are no complicacies in the form of ownership of land in Korea, the conceptualization is focused on the power of ownership rather than the form of ownership about the immovables, which is unlike the common law system. then there are generally three elements of power of owners, regardless of the distinction of movables and immovables. The power to use, profit, and convey the object, which is subject to his or her ownership. That element plays to yield two types of real property in Korea. The first type can have a subcategory of leasehold interest and two kinds of right for exclusive use. And the second type could be a mortgage right. The two kinds of right for exclusive use can be termed land-connected easement. One is the right of owner of adjacent land to serve the need of his land. And the other is the right to own the things permanently attached on the land, including many of construction, such as house, buildings, and so forth. The two kinds of right is, again, on its tangible form attached to the land. The right to use the land for personal need may disqualify as a right of real property, whether it's considered as contractual or as one of essentials attached to the relationship between the adjacent lands. From this point of view, the easements or equitable servitude in common law system can be distinguished to say they are perceived as one kind of real property right in common law system. Again, all these land-connected easements recognized in civil law countries are real property right, like a perfect form of ownership that can only be effected in terms of legal instance by public recordation with the public office. Unless the legal instance arises from the statutory cause, including succession or public auction, and so forth. Interestingly, there is no independent scheme of land-connected easements to own the things permanently attached to the land in the common law system, unlike the civil law countries. Therefore, concerned people need to make some of other legal arrangement if the ownership of things and lands are to occasion a separation, which could be normally contractual in nature, unlike the real property scheme in civil law counterparts. A little further, when the Korean lawyers discuss the acquisition and sale of transfer of property, they also rely on the basic classification between movables versus immovables. The reason for this classification is partly because we adopted the German modality of property law, which requires the recordation to validate the transfer of immovables or land. It is in sharp contrast with the acquisition or transfer of movables or chattel that requires some form of delivery to validate it. Both traditions seemingly go the same in this context. But the crucial point is that, as I have pointed out previously, the transfer or sale of land be completed to that effect only through the delivery of deed, the kind of instrument of dispositive nature in the United States. The discourse about the land ownership in the United States, as I have said, may take a distinctive nature arising from a feudal heritage, which would cause its preference between the movables and immovables. The feudal heritage has ceased in Korea from the unilateral incorporation of Japanese emperor. But from our liberation, there has been serious public turbulence about the land ownership in newborn republic around 1945, 1948. For example, some leftist circle implored on uncompensated taking and gratuitous grant of agricultural land, which proposition has been rejected in the event. While we imported the German mode of civil code, the real property has been marshaled as a statutory form, centralized in a simple concept of ownership, And we can see no vestige, unlike a communal system. What is the difference between the land reform and Java reform? Recently debated surrounding the presidential election. How do you perceive that? Besides the way of approach, your further investigation can well disclose the very similar elements of real property right between two traditions to serve the public policy or administration and the goals of justice in this area of law. That's true when we focus with a substantial perspective on a particular institution itself. If you like to be a comparativist, it is necessary to see the historical context and its way of operation to develop the legal culture or system. More importantly, the incident of history is in many ways never determining to totally dismantle the previous mode of legal tradition. For example, the communist revolution of Bolshevik in Russia did not totally eradicate its subscription to civil law tradition. Rather, the law reforms thereafter may heavily reinstated the previous system originating from Germany and France. The law is actually a living creature on its own to preserve its distinct domain in view of its culture and scientific system. For the year of German codification was as late as 1890s, we would be certainly late to establish modern type of civil code, but the worst might, according to some commentator, to be the extraneous nature to be forced into the capitalistic society by Japan. Do you agree? Personally, I like to spend my leisure time to view TV drama, especially the spectacles of ancient history. Do you like Sangdo? As I've introduced, in English translation, A Merchant's Ethics. It was viewed in TV a decade ago. It was revived in local cable TV, and that is a time killer for my case. It was amazing that we can trace some of capitalistic minds around as early as 1800s. So we'll look through the types of tenancies. There are three types of tenancies covering a tenancy for years, a periodic tenancy, and tenancy at will. A tenancy for years is one with a beginning and an end fixed from the outset. Usually this is fixed by a calendar computation. For example, 1 year or 2 months, so forth. And the term for years differs from all other tenancies in that it has a definite ending. It expires without notice, where the date of a termination is fixed but uncertain. Usually a term for years is created since it is closest to the party's intention. Unless there is a contrary statute, a term for years can be for any period, even 100 years or more. A tenancy which continues from period to period until terminated by landlord or tenant is a periodic tenancy. The periods can be from month to month, from year to year, and so forth. A periodic tenancies may be created by agreement of the parties or by provision for payment of rent monthly, annually, or so forth. If an annual rent is specified with monthly installments, according to the majority view, the period is from year to year. A periodic tenancy is created by operation of law, where the landlord elects to hold the tenant to another period when the tenant takes possession under an invalid lease and pays rent. Notice must be given by one of the parties to terminate a periodic tenancy. Notice must be given within a period equal to the period of the tenancy, with the general rule that 6 months' notice is the maximum required. Notice must be given prior to the expiration of the current period and must terminate the lease on the last day of a period. Then what is tenancy at will? A tenancy terminable at the will of either the landlord or tenant is a tenancy at will. A tenancy terminable by only one of two parties is not a tenancy at will. A term of years, periodic tenancy, or life estate can be made terminable at the will of only one party. If the tenancy is not a term of years or a periodic tenancy or life estate and is terminable at the will of only one party, by law, the other party can also terminate at will. At common law, no notice was necessary to terminate this tenancy, but statute today usually requires 30 days notice to terminate. And in some cases, tenancy sufferance may be created. A tenant who holds over when his term expires is a tenant at sufferance. If the landlord consents to this, the tenant becomes a tenant at will or a periodic tenant. When the tenant holds over, the landlord can evict the tenant, can sue the tenant for damages, or can elect to hold tenant as a periodic tenant for another term. In some states, landlords are given other remedies by statute, such as requiring the tenant to pay double rent. For the arrangement of a non-freehold estate, we have to know the operation of statute of frauds. Oral leases for short terms, such as a year, are exempt from the statute of frauds. This is generally true even when the year lease is to commence in the future. Entry and payment of rent under an oral lease creates a periodic tenancy with the periods determined by the rent payments. In the case a Cook versus University project, the core rule, an agreement must specify what property is to be used in order to constitute a lease. The case shows a distinction between the lease and license. In this case, a statute law requires the landlord pay interest on security deposits to pay tenants. So the issue is whether the usual arrangement about the university dormitory can qualify as lease other than mere license. It is also pertinent to your personnel in this university. Let's see the back pattern. In this case, University Plaza, who was a defendant, was a private-owned university dormitory. A defendant's contract with the students required to provide accommodations, basic furniture, parking facilities, cleaning services, and so forth. Students were required to pay a security deposit. They could cancel the contract for default, but the resident could not cancel. A defendant retained the right to assign space, to authorize or deny room and roommate changes, and to require residents to move from one room to another. A cook, who must be a student, and also a plaintiff in this case, and other residents brought suit to require defendant to pay interest on the security deposit. The state law requires landlord pay interest on security deposits to tenants. the trial court sustained this motion to dismiss on the basis that no landlord-tenant relationship existed between the plaintiff and defendant. And the plaintiff appealed. But the higher court affirmed the lower court judgment. So held that this arrangement is not a leasehold interest, merely a license. And in the case titled Womack versus Heiss, decided in 1987 by Alaska Supreme Court, the court found that a certain term is one of the essential requirements to entitle a lease for a term of years. As the history of the United States is related, the discrimination in selection of tenants would be one of a cross-sections, the public law and private law into place. One of the interesting cases involved the nature minor in the residential context, which we can see later. Historically, a landlord was free to rent to whomever he pleased. Federal and state statutes now prohibit discrimination in the rental of property on grounds of race, color, religion, or national origin. These statutes ordinarily apply to both sale and rental of property. The two major acts are the Civil Rights Act of 1866 and the Fair Housing Act of 1965. They are both well exposed to many of Koreans also. In this context matter in the courtroom, a plaintiff need not prove that the landlord has discriminatory intent to show a violation of either Section 1982 or the Fair Housing Act. Proof of discriminatory impact is sufficient to make out a prima facie case. Once the plaintiff makes a prima facie case for discrimination, the burden shifts to the defendant to prove that race was not one of motivating factors. And against our normal expectation, one of the most representative cases arises from the context of a minor concerning the apartment complex. Do you think the apartment complex may bar minors under the age of 18 residing in the premises and later changes policy, refusing to renew the previous agreement? In the case titled a Marina Point versus Orpheus, decided in 1982, the state statute prohibits discrimination based on sex, race, color, religion, ancestry, or national origin by any business establishments. But the statute does not expressly cover the age element. So we need to consider if the provision is illustrative in nature or restrictive. We need next think about the nature of statute. If we perceive the basic distinction between a public versus a private, one can see the statute as obviously of enforcing nature to eradicate the social evils and can invalidate the contract itself, and never just one of a regulatory nature with fines or penalties. That is a normal way of approach that the Korean lawyers think about. And on the position of a United States Supreme Court, there is no sharp distinction between this dichotomy. And usually the regulatory laws are held to be capable of invalidating the underlying private contract. But in the Korean context, we may consider the statute can be invoked just to impose a fine, where the leasehold agreement in private terms still stands on effect. In this case, the depending opinion pointed out the facts found by the trial court should be binding on appeal, and the statute does not prohibit the exclusion made by plaintiff, which is based on evaluation of the facts. And the majority court ruled the landlord may not exclude children as a class from occupying a rental property. So it is very a delicate problem, but posed very frequently through the public intervention about a critical social verge. As a matter of definition, the tenant of leasehold interest has the right to possession. The landlord has the duty of transferring to the tenant at the beginning of the tenants the legal right to possession. If another person has paramount title, the landlord is in default. Paramount title refers to any title or interest in the lease land held by a third party at the time the lease is made, which is paramount to the interest of the landlord. For example, before leasing, L gives M a mortgage on the property, which M records. Then M has a paramount title. The tenant's obligation to pay rent is dependent upon the landlord fulfilling his obligation to provide the legal right to possession. And second, fulfilling his obligation to not interfere either directly or indirectly with the tenant's physical possession. And third, in most jurisdictions, to place the tenant in actual possession. We now need to review the tenant's right to possession. So let's see the problem of possession during the existence of the lease. If a tenant is physically evicted from the entire lease premises, either by the landlord or by someone with paramount title, the tenant's obligation ceases. Having been deprived of possession of the entire premises, the tenant may treat the lease as terminated, and his liability for further rent under the lease is discharged. Against the actual eviction, the court developed the concept of a constructive eviction. The common law covenants in leases were viewed as independent. The breach of covenant by the landlord did not relieve the tenant of his obligation to pay rent unless there was an actual eviction. The doctrine of constructive eviction was developed to mitigate the harshness of the theory. It serves, in fact, to make the obligation to pay rent dependent upon the landlord's performing his covenant of quiet enjoyment. So, where through the fault of the landlord there occurs an interference with the tenant's use and enjoyment of the leased premises, which is serious enough to force the tenant as a reasonable person to vacate the premises, the leasehold is terminated by constructive eviction, and the tenant is excused from further rent liability. In the case titled Adrian versus Rabinowitz, the court ruled that a lessor does have duty to put the lessee in actual and exclusive possession of the leased premises at the beginning of the term. It conforms to the American rule in this context. According to American rule, which is a minority view in the current jurisdictions, some jurisdictions maintain that the landlord has no duty to deliver possession to the tenant at the beginning of the lease term. Thus, if a prior tenant wrongfully holds over, the new tenant has no cause of action against the landlord. Behind this American rule, there is a rationale. The new tenant has a cause of action against the prior tenant, and thus there is no need to hold the landlord liable for the tortious acts of a third party. But we have an English rule which is similar to the law of Korea. In most jurisdictions, the landlord has the duty to deliver actual possession as well as the right to possession at the beginning of the term. If the previous tenant has not moved out when the new tenant's lease begins, and the landlord does not remove the person within a reasonable period of time, the new tenant can terminate the lease or recover damages from the landlord. This is known as the English rule, and is adopted by Restatement Second, Property Section 6.9. In the case titled Blackett versus Olanoff, decided in 1978 by Massachusetts Court, the court confirmed the constructive eviction rule. According to the court opinion, tenants may assert constructive eviction when other tenants who are under the control of common landlord breach the implied covenant of quiet enjoyment. The landlord-tenant relationship requires a consideration of the condition of premises. Modern legislation typically requires the landlord to make the premises tenantable at commencement of the lease. The core of consideration in this respect can be an implied warranty of habitability. A discernible trend exists to imply in residential leases a warranty that the premises will be habitable at the beginning of the term. Evidence of uninhabitability is often found in violation of health and sanitation ordinances. Breach of this implied warranty may constitute grounds for rescission of the lease agreement and may create a cause of action in the tenant for recovery of expenditures made to render the premises habitable, and may suspend or excuse the tenant's duty to pay rent. In case Javins versus a Fourth National Realty Corp, the court ruled that violations of housing code constitutes a sufficient breach by a lessor to allow the lessee a suspension in rent payments. Okay, time is up, and I have to defer my discussion for next class, and see you in the next class.